Hello, everyone. So before I begin in earnest, if during the presentation people are finding it difficult to hear me at any point, if you could just let me know through the chat and I'll stop to see if there's a technical issue at my end. Also, if anyone has any questions coming out of the talk, please feel free to drop me an email or give me a call after the talk. My email address will be on the last slide. So I'm just going to share the screen for everybody. Okay, so the aim of my talk this morning is to help give you all a helpful overview in about 15-20 minutes of some of the key points to consider when you're making a Section 2036 application or representing someone who is thinking about whether a Section 236 is appropriate, or someone who might be in the sharp end of one as well. So I've tried to keep a close focus on what factors you might want to think about when you're deciding whether to make a 236 application, and what concerns a lay client may have and might ask you about as well. There's quite lots of interesting elements about the applicability of 236 out with the UK and foreign jurisdictions using 236 within the UK. But unfortunately, I don't have enough time today to go into that. But if you do have any questions related to it, do drop me a line. So if I could sum up my talk in short, I would say Section 236 is a very useful and powerful tool for office holders to compel information and documentation to help them comply with their statutory duties and aid recoveries. However, there is much that can and often does go wrong. And what I think you can see through the case law and through successful applications is that they always have a very keen focus on what information is necessary, why it's necessary, and why it's necessary to compel that information from the person or the company who is at the sharp end of the 236 application. Before I go into some of the more details of it, I'll just talk through some of the sort of fundamental concepts I was sort of alluding to in my summary there. So the first thing is the 263 application is always about fact-finding. So about releasing documentation material or compelling someone to come to court for a private examination. So that's being asked lots of questions about their affairs or details about the company's assets, what's happened to the property, why did the company go into liquidation, and so forth. Because they are their own fact-finding exercise, they are their own distinct proceedings because they're looking for facts. They're not finding out what's happened and applying it to law. Is about finding out what has happened. So the purpose of the 263 is always going to be in the court's mind when they're considering any application and also any examination therein as well. And much of the case law, and you can see it in the successful applications, hinges on whether the individual 263 application is being used appropriately and proportionately for the legitimate purpose of finding information to aid the office holders in their duties. And because it's in the aid of the office holders' duties, the applications are always going to be seen as part of the broader court-supervised winding up proceedings. So the courts will always keep an eye on that process and will not be afraid to restrict the examinations. So, moving on to some of the more practical matters. Who can apply for a 236 order? Well, that's fairly straightforward. That's defined in 263(1). So that's an administrator, a liquidator, or varieties therein. Now, this might seem fairly obvious, but recently I had to short a draft defence to the point on someone who was not one of these four trying to launch a Part 7 claim under 263. So whilst it was wholly inappropriate, these mix-ups do happen. So just be aware of that. And also foreign insolvency office holders who are akin to an administrator or a liquidator, they can, with court discretion, apply for a 236 order for a company in the UK. Now, who a 236 order could be sought against is much wider than who can bring it. And as you can see, it is a very broad group of people. So it's basically anybody or anyone or any company that is connected with the liquidated company or the company in liquidation, and anything that went on therein during the company's business, during its company's downfall, what happened to the property and assets of it. Now, what is notable is that the section doesn't prevent office holders from bringing a 236 order application against someone who they have decided they're going to bring proceedings against, such as for a transaction under value and the like. However, such an application cannot be used oppressively, and that will be a word I'll be using repeatedly for the rest of the talk. But it's going to be an important thing in assessing whether a 236 application can be made against someone the liquidator or the administrator is thinking about bringing proceedings against. Now, let's go into a bit more of the nuts and bolts here. So what does a Section 263 require to have in its application? So the rule is set out in 12.18. And so you're going to need to have a notice, supporting evidence, and a draft order. And it's going to be up to the applicant to show to the court that first, they could not have required the information any other way. So that means actually the first step comes before this. You're going to have to ask the other side for that information. And in most circumstances, you're also going to have to give notice to the other side that you're going to make a 263 application. If you do not give notice and if you do not ask for the information beforehand, the burden will be on you as the applicant to show that there were sufficient compelling reasons for doing so. Otherwise, going straight to an application may count towards the court ruling the application is oppressive. And it is very much the extreme example, without notice and without asking the other side first. The leading case law is to do with the Maxwell liquidation in the 1990s. So it's that sort of level of wrongdoing that might allow a without notice and without pre-action correspondence between the two sides. So it's very, very much a exception to the rule. Now, of the three, the one that actually probably the very vital one to have a proper think about before you do any of it is the draft order. A lot of thought needs to make sure that it's compliant with the rule of 1219, and it needs to set out clearly who the person is going to be required to comply with the 263 is going to be, and that the scope of the order is sufficiently specific and not too broad-ranging, as well as finally setting the time and manner for compliance of the order. And that's particularly important if it's going to be an examination of a person, so bringing somebody into court as well. And for that, there must be 14 days after the date of the order when it's given for the examination, unless the court orders otherwise. But again, it's a bit like the without notice issue at the last slide. It's very much the exception, a much shorter notice period than 14 days than it is a longer period as well. That's generally because people are required to bring documentation along with them as well and get their affairs in order. So all three of these, the application notice, the witness statement, the draft order, really do need to be focused on why the order is necessary, why the information is necessary, and why it has to be the 263 route to compel the information out of the other side. And if you can't convince the court on all three of these, the application is likely to fail. So, moving on to how the court will assess whether to grant your 263 application. So it's at the court's discretion, and it's explicitly a balancing exercise. So it's a balancing exercise between how important and necessary the information is to the office holder against the degree of oppression, that's that word again, to the respondent. And the two leading cases, and I recommend highly reading them if you want to get a grasp of the principles behind the court's discretion and the balancing exercise are both from the Court of Appeal. So the first is Clover Bay, which sets out the balancing. And then the second one is British and Commonwealth Holdings, which looks more at the oppressive factors, which might weigh against the need for the information. Pretty much all the other cases, or the important cases that I will be citing today, flow from these two. Now, as we all know, when it's at the court's discretion in a balancing exercise, the court's ruling is going to be very fact and context sensitive. But I think it's governed by at least three principal considerations and three questions. So, again, it's how necessary and relevant is the information? What's the reasonable grounds for believing the person and the company has the information? And then oppression. I'll come back to oppression in a minute. So thinking about these three questions, I think really helps focus the mind when you're drafting your application notice, your witness evidence, and also your draft order. Now, again, it's very difficult to give very hard and fast rules because of the discretion. But one thing I think is true is that caution will be exercised if the application is very wide and also very intensive as well. But considering it really depends on the circumstances, so in the case of Chesterfield United, because there was the respondents were being very cooperative and the liquidators need to get as much information as possible, the court then allowed a much wider Section 263 order than normally. And in fact, they used the words venturing into fishing expedition territory. So it's a 263 application can be on that line between, specific disclosure and an outright fishing expedition. And it's probably more towards the fishing expedition than it is towards specific disclosure. But again, it really depends on the context of the case. So talking about oppression, because this really is the key one. It's the most contentious. So the wording is actually not it causes oppression, but that it's unreasonably oppressive. Because by its very nature, the element of compulsion that you're going to get in a 263 application is going to be oppressive to the respondent. It's a question of how oppressive and how necessary that is. And then that's the weighing factor. And what I would say is that courts tend to be more sensitive about oppression when it might involve an innocent third party than, say, a former registered director of the company. So, for instance, there's a case called PFTZM Limited in liquidation, where a fishing expedition against potential shadow directors was not allowed because they were potentially innocent third parties. But if they were shadow directors where there was good information that they were shadow directors, it might have been allowed. But it's because it was a more speculative application to find information to prove that they were shadow directors, it wasn't allowed. Another factor is that if someone has already given information to the company, so say someone's given a detailed witness statement already, the applicant is going to have to make very good reasons why that earlier disclosure, that earlier witness statement, is not sufficient. But it is possible. I mentioned a little bit earlier that Section 236 can be used against someone the office holder has decided to start proceedings against, but has not yet issued. And the court will assess oppressiveness in this context. And I think the two principles they'll be looking for is, one, the applicant's not using 236 to gain a special advantage or some form of specific disclosure or evidence or to get an admission for the claim to come. So, for example, if it becomes clear that the true primary purpose of the 263 is to find out the defendant's defence, well, that's not going to be allowed. But if it's more specific in that instance to find assets which need to be recovered, that's probably going to be fine. So, And then one last point would be that when a claim is issued to avoid a time limitation and it's not really progress much further than that, those situations, a court will be more willing to give an order than not. So, coming to three final points which might be of interest to you. So first is legal professional privilege. So the first is privilege does not extend to documents that belong to the company or which the company had a right to, which is in the hands of third parties, and that includes solicitors' firms. So in that situation, if you have or you are subject to such an application and you have these documents, you're going to have to give them up. They're not yours to have. But if there are normal legally privileged documents such as advices and the like, emails, conversations, which would normally attract privilege, they will attract privilege in such an application. So I think that's important if you're the respondent to an application, but it's also important if you're an applicant as well, because in such a situation, you'll need to make sure that your drafting is very precise and on point. So you're only picking up the documents which privilege does not cover. Otherwise, you could then get bogged down in lots of discussions about privilege, which, as we know, can drag on and increase costs and time as well, which is often a factor in these matters. Now, confidentiality, that's really about information that's gathered in the public examination, whether that can be used in other proceedings. So because there's a close link sometimes between insolvency and fraud, the case of Saunders should be in forefront of your mind if your client asks you about this. So in Saunders, this was a PHRC case. It was because it's a compelled testimony, because the respondent is compelled to go to court. Anything that they say which incriminates themselves directly cannot be used in criminal proceedings subsequent, because it's compelled. However, there's a sort of little loophole. So information which is not directly incriminating, but show that the examinee, shall we say, has a loose grip on the truth, but does not directly incriminate on a point, these can be used by the police and prosecutors. The one sort of pseudo exception to all of that is directors' disqualifications. I'm sorry, I'll amend that. It should be directors' disqualifications, not qualifications. Those, if there is compelled testimony in an examination, those can be used for those proceedings. And the last one is witness immunity. So it was clarified in that case, Mitchell and Al-Jaber, that there's witness immunity from suit for evidence given at the examination. And finally, costs. Final point of almost all litigation. This is governed by the Rule 1222. And like costs and like these applications, it affords a great deal of discretion to the court when it comes to costs. Normally, there's some certain normal rules, but then it really depends on the behaviour and the context. So normally, the applicant will be asked to pay a reasonable sum for travel expenses if a respondent is ordered to attend an examination. Normally, the respondents will bear the cost of producing documentation under the order. But there is, again, a loophole under 22.1 that the cost of examination can be borne by the respondent if there's been an unjustifiable refusal to provide information. And then the final one is for costs if the respondent wants a lawyer to come with them to the examination. Normally, again, that will be the respondents and the respondents alone. Again, depends on circumstances, and depends on the questioning and whether it emerges in the examination, whether the examination is oppressive and goes beyond the scope that's been ordered and the like. So that's the end of the talk. Thank you for staying with me. As I said at the beginning, if you have any questions, if you want my slides, please let me know. just drop me an email. I also know it'll be on the website soon. Thanks very much for your time.